Welcome back to Brazil Crypto Report. Today I'm joined by Daniel de Paiva Gomes, who's a partner at VDV Advogados and one of Brazil's leading experts on cryptocurrency taxation. We talk about why Brazil's framework for crypto taxation is one of the most advanced in the world, as well as new legislation that seeks to change the tax treatment of offshore crypto holdings. Great. So we are here with Daniel de Paiva Gomes. Daniel, it's great to have you on the show.
Thanks, Aaron. I'm glad to be here with you.
Amazing. So Daniel is one of the leading cryptocurrency taxation specialists, experts in Brazil. He's been practicing in this area for a while, and he's even written a book on the subject. So it's a real pleasure to have him here to share his knowledge with us. And Daniel, to get started, why don't you give us a bit of an introduction to yourself, your professional background, how you got into crypto, and how you spend most of your time now.
Perfect. Well, first of all, I would like to say that I'm super excited to be here with you, Aaron. I have been following your work for quite some time, so I'm truly honored to be here with you to share some thoughts on this matter.
Thank you.
Well, my professional background, I always have like a two-sided life. I have my law firm, my office, which is called VDV Advogados, Via Rodrigo Vasconcelos and Paiva Gomes Advogados. And also I have a research life, as I would say. So I'm also a professor, and I like to research about crypto, write books, write papers, and etc. So my background is basically focusing on doing business as a whole, you know. So if I'd say on a formal perspective, from a formal standpoint, from a legal perspective, I would say banking services, financial markets, and taxation. So everything that is connected from a B2B perspective and also a B2C, but doing business is my main role here in the office, you know. And how I fell into crypto, basically in 2015, I had some clients that are from the gaming sector, and they were like participating in some tournaments, and they would get these prizes that would be paid in Bitcoin. And they were like, Daniel, can I receive Bitcoin? How should I tax this? And is this legal at all? And you can imagine that the bias back then was even worse that we have nowadays. You know, currently we have some prejudice, some bias from people that don't understand the technology and does not separate the good players from the bad players. But back then was even worse. At that time, me and my brother, Eduardo de Paiva Gomes, we have this channel on Instagram, which is called Os Irmãos Paiva. We always research and work together. And we decided that in order to help them to solve this question, we should dig deeper on the technology itself. And that was when we already had took like post-graduation courses from a more broad perspective on doing business, taxation. And then we decided to move forward with our studies from a more stricto sensu approach. So to get a master's degree, to get a PhD. But in order to do that, so imagine that back then we solved this issue. We concluded that they could accept Bitcoin as a means of payment, and they should tax it basically as something that was given to them. So it was a remuneration. But we decided that we wanted to get deeper on this subject. And in order to do that, we needed, because it master's degree, they demand that you have a professor to give your guidance, you know, for the purpose of the MAC, which is our authority here in Brazil, responsible for education. We need to have a university that accepts your project and a professor that is going to be responsible for giving you guidance, you know. And back then, I am from São Paulo, Eduardo too, and no professor, no university was willing to accept these topics, you know, because they would say, no, crypto is for criminals, crypto is a Ponzi scheme, and there is no asset reference attached that would give intrinsic value to this kind of asset. So it was very odd for us to try to show the obvious, you know. The technology has nothing to do with the bad use cases that some bad players would do with it. It took us for 2 years to convince them that this is okay, this is a healthy market. So fortunately, after talking to several universities, the Escola de Direito, School of Law, of Getúlio Vargas Foundation here in Sao Paulo. They accepted my project, was focusing on regulation taxation of crypto. And Eduardo's project was more focusing on NFTs and 3D printing. I started my research at 2017 and he started 2018. Each one of us took like 2 years to conclude it. And fortunately, these researches were awarded as the best of their respective seasons. And after we got invited by Thomson Reuters to convert this research into a book. So my first book was this one, which is Bitcoin, the Taxation of Cryptocurrencies. I have one copy for you. We just have to schedule our coffee, Aaron.
Okay.
And this book is more like for lawyers, you know, for tax lawyers, for financial markets lawyers, banking lawyers. So it's more technical. But after that, we understood that, and imagine that it was around 2018, 2019, and we understood that the technical aspects of blockchain, they are so disruptive that it is important to have a standalone approach. What I mean by that, I don't want to be a banking lawyer doing crypto. I don't want to be a financial markets lawyer doing crypto. I don't want to be a digital lawyer, which is more focusing on privacy, doing crypto. I want to be a crypto lawyer. And for that, I need to understand the intrinsics of the technology itself. And the boom of the ICOs that happened around 2018 show me that, because it's not crystal clear if you how you should conduct things from a legal standpoint on the crypto realm, you know. So the most famous things that people think that crypto lawyers only do that, but it's not true. The famous Howey test to evaluate if a token is a security or not. So this is just the beginning. There is like 360 degrees approach that could be taken and should be taken into crypto projects. And that is the reason why I decided with Eduardo to take the master's degree on University of Nicosia in Cyprus, which is more focusing on computation. So it's a master's in science computation targeting blockchain and digital currencies. And fortunately, we were accepted and we got a partial scholarship to do that. So it was very we were thrilled to have this opportunity because it's not very common for lawyers to go into the science computation aspect of it, but they allowed. So we were very happy for that. We concluded this master last year, and we decided to get in the PhD from a legal standpoint. So we went for legal, then we back to tech, and now back to legal again. And my PhD is about the usage of smart contract embedded with artificial intelligence to control overruling and on-binding cases from the litigation and Supreme Court of Justice. And Eduardo is more focusing on the metaverse. So you can see that we have this more deeper analysis on crypto projects. We like to deliver something that is very connected to the technology itself, but also compliance by design, compliance by default, to avoid any kind of problems and to ensure a very multi-jurisdictional approach because crypto is global. But even though it's a global thing, we know that licenses are required in the jurisdiction of your consumer market. You need to be in compliance with several countries depending on the size of your operation. That is the reason why we decided to take a specific certification on international tax planning from the International Bureau of Fiscal Documentation, which is called APCIT, Advanced Professional Certificate on International Taxation. So this way I could say that we have established very solid grounds on our crypto desk on VDV, which was created like in 2018. So we have 5 years now, and to deliver some legal solutions that are very complete, and they are not going to struggle innovation. So this is what I have been doing. And I would say that my research is also my passion. And this is the second gift that I want to give you. It's very, very little, as you can see, Aaron. This is our second book. It's a
Oh
collective
my.
book, actually. We have like 94 authors from Brazil, United States, and Europe. And this is not a legal book. This is this is why I'm so in love with this research, because we got all these people together to deliver a book focusing on 4 pillars: philosophy, technology, economy, and law. So legal is the last part of it, because the law should be seen as an instrument, not as a dead end or something that would be consumed in itself. So this book was also published by Thomson Reuters, and we have the pleasure of having people from the Brazilian Securities Exchange Commission, people from the Central Bank of Brazil, to deliver something that would bring together regulators and entrepreneurs to build good and healthy solutions for the crypto markets.
Amazing, amazing. And I guess for those of you watching or listening to just the audio, he was showing this like 500-page hardcover book full of which are all in Portuguese language about the subjects you were just talking about: philosophy, law, tech, everything. So that'll be some good training for my Portuguese reading, to to work on that.
Definitely.
So appreciate that. And I love kind of where you're coming from here, really taking like the holistic approach, because I do agree with you that crypto is it's very hard to approach crypto and just be like, well, I'm just going to look at this from the legal perspective. I'm just going to look at it from the tech perspective. I'm just going to look at it from the cryptography perspective. You have to kind of be something of like an intellectual Swiss Army knife, right? And kind of understand, you have to have all these kind of tools in your tool belt and really understand how all the pieces fit together. And it's very, this is one of the things that really attracted me to crypto in the first place, was just like, wow, it's like all these areas that are super interesting in their own right. Then you kind of fuse them together and you get this kind of fun and crazy wild world of crypto and blockchain, right?
Yeah.
So, but kind of shifting gears here and really focusing on the tax portion, I would love for you to give us kind of a quick overview, or maybe I guess to the overview to the extent that you think is sort of beneficial enough for folks to really understand without going super deep into the weeds, of just how the current Brazilian crypto tax framework is structured. I know there's been a few, dating back to even like 2019. There's been a decent amount of guidance on this, and I think that will help kind of set the table for this legislation that is advancing through Congress right now, and it'll help us understand exactly like why this legislation is important right now.
Perfect. So first things first, Aaron, and for those that are not like tax lawyers or accountants, it's important to understand one thing. Any country, in order to tax something, needs to have a nexus with a person or a thing. And we have two kinds of nexus: source and residence. Source of payment or source of production of that wealth, and the residence of the person that is going to receive that wealth. There are countries that they are only they have a territorial approach. What this means: only the revenue that is generated within the territory of that state will be taxed by that state. Meaning that if you are a resident of that state and your source of revenue is abroad, your country of residence will not tax this revenue. We'll have other countries that they are considered worldwide income countries, like Brazil, and they will tax according to residence. There are other countries that they are more aggressive on that. They will tax based on the citizenship, the nationality. For example, U.S., if you are a U.S. citizen, you are national, American national, even if you are a resident in Brazil, you will need to pay taxes for the United States because of your nationality. And you have to pay taxes in Brazil because you're residents. And if your source is located in another country, the other country, because it's the source, probably will withhold taxes there too. So that is why it's so important to have this dual thing in mind: residence and source. So Brazil is a worldwide income country. What this means in practice: if you are a resident of Brazil, you need to pay taxes here, regardless of the localization of the source of the income, of the source of the payment. So why I am starting by this broad perspective? Because even if we did not have the project of Bill of Law 4173, which are offshore Bill of Law, even if we didn't have that, all crypto for any citizen, for any people living here in Brazil, which is a Brazilian resident, should be taxed in Brazil. This is the rule of the game. There's nothing we can do about it. This is the nexus. If you live here, if you have a residence here, you need to pay taxes here, regardless the localization of your source. This means that if now, currently, there are people that are operating from like virtual asset service providers located abroad that have no physical presence in Brazil and they're not paying taxes, this is a crime. And we don't need a new law for that because our system is based on worldwide income. And what is the status quo now? And let's ignore for a moment the recent bill of law that was approved in the Chamber of Deputies. We have this worldwide income system, meaning that if you acquire income, income is considered to be like the result of your work, of your labor, or the result of investment. But besides income, you have other kinds of revenue or other kinds of profit, and these would be more related to capital gains. We have these two kinds of things, and when, for example, you pay someone or someone is paid, regardless of the source, this is very important, you receive something as a payment in kind in crypto because you deliver a service, because you sold a good, anything, this should be taxed as income arising from labor, which means that we are not going to the capital gain rules. We are going to the ordinary income rules. So if you are a natural person, you should tax it according to our progressive rates until 27.5%. If you have an alienation event, so you're going to sell, you're going to barter, you're going to exchange, this is going to move out from your property, then you have capital gains taxation. And regarding this capital gains taxation, which is the most common, the Federal Revenue of Brazil has already enacted several Q&A explaining how to tax that. And they say that capital gains should be taxed from progressive rates from 15 to 22.5%. However, you have an exemption for small value transactions. So what are the small value transactions? If in your month, the amount of transactions that you have conducted does not surpass thousand reais, would be more or less on the exchange rate of today, $7,000. The group of these transactions is exempt. So it's not a capital gain of 35,000 reais. No, it's the amount, the group of transactions in that month that should not supersede 35,000 reais. So this would be an exemption. It's a very good exemption for the ordinary citizen in Brazil because it's a high value for the average person. And it's also good because you enable crypto to act as an actual means of payment because you don't need to start evaluating capital gains. This from the perspective of taxation itself. From the perspective of like duties and declaration and tax reports, we have from natural person standpoint, we have an annual obligation around like April or May of the next year. You need to report your position in crypto that you have on December 31 of the previous year, but you should only report crypto that you have on December 31 if the cost basis of this crypto is equal or superior to 5,000 reais. If it is below, you don't need to report that on your tax report. And you have 5 types of crypto on this reporting declaration form. You have under group 8, you have 5 types: Bitcoin, altcoins, stable coins, NFTs, and residual tokens. What would this last category would encompass like tokens precatório, it's a public title that the government needs to pay a person. Also consorcio, which is like a group of people investing together. You have like the fixed return tokens, which some Brazilian exchanges are selling. These would be encompassed by this last category, which is the residual tokens. So it is very important. The reporting duties have nothing to do with taxation. People think that they should not declare, they should not report in order to avoid taxation. No, you should report everything according to the triggers and the rules that I just explained to have the source of your wealth. Because imagine that you bought crypto and then you have a giant upside. Your average income is like 3,000, 4,000 reais, and then you show up with an apartment or with an expensive car. Someone would be able to prove that this is licit, this is legal, So it's very important to have this in mind. People think that because crypto have this anarchic, anarchist perspective, but people need to think about their own wealth and to plan this growth along the time, throughout the time. And in order to do that, they need to have the origin of the assets that they buy. So that is why it's so important to have this report every year conducted in a very serious and compliant way. And the last thing, we have the super famous report from the normative instruction 1888 from 2019, which is not dealing with taxation itself again. It's more focusing on reporting and what is going to say basically. If your transaction with a virtual asset service provider located in Brazil, don't worry, this intermediary is responsible for transmitting this report, But if your transaction like with no Brazilian intermediary, which would encompass, for example, a foreign exchange, peer-to-peer, decentralized exchange, you yourself, for a natural person or a company, you need to do your own declaration, your own reporting for the purposes of the normative instruction 1888. What this means, if you, in a month, has an amount of operations that it's over 30,000 reais, then you are compelled to make this declaration, to transmit this report. If you are under this threshold, you don't need to declare that. And this is very important because sometimes the media says, oh, because this foreign exchange is not compliant with the Brazilian federal revenue, because it's not going to transmit the reports from their Brazilian users under normative ruling, normative instruction 1888. This is fake news. This is totally incorrect. They are not obliged to do that. Who is obliged to do that is the user. The rule is clear. Now, if you are interacting with no Brazilian intermediary, you need to declare that. You need to fill out the forms. You need to transmit the reports, not the foreign exchange, not the peer-to-peer platform located abroad, and neither the DAX developers that eventually are located abroad. They have, in this bill of law, actually, they have a new article saying that the new company, the foreign companies may be forced to comply with that. But the current state, our status quo, is not demanding that. It's demanding that the user does that. And what is this different from the bill of law that is pending and was recently approved in the Chamber of Deputies? Again, this bill of law, in my perspective, we should not confuse things. This bill of law is not going to ensure tax collection over operations that are conducted overseas. And why is that? Because the current rule already encompasses that. And people are not paying taxes, not because the absence of a rule. It's they're paying taxes because they want to evade taxes. So it's a criminal perspective, it's illegal. I'm not going to dive into that, but it's very important to have this in mind. This bill of law is not going to solve this issue. This bill of law is creating a different scenario for people that are conducting transactions overseas. Why? Because today you have one rule for capital gains that are accrued in Brazil or abroad. And this is the rule that I just described. Progressive rates for 15 to 22.5%, and exception for small value goods on 35,000 reais. Under the new rule, what they are doing is separating, the domestic operations in Brazil, they are going to stay in this framework, 15 to 22.5%, and the exemption of 35,000%. On the other side of the coin, what we have is a new rule to treat differently the operations conducted overseas. And this rule is going to have a fixed rate of 15%, okay? And this is interesting because if you are like a high net value investor, it will be cheaper to transact with foreign exchanges than the Brazilian ones. Because under the domestic scenario, imagine your transaction 1 million, 2 million, 3 million reais, you're going to tax from 15 to 22.5%. Under the new and proposed scenario, you have a fixed rate of 15%. So this is the first difference.
So just to pause you there. So this would actually, in that scenario you just described, this new law or this new proposal would actually be beneficial for the Brazilian crypto, like a high net worth crypto investor who has like you're actually paying, so you'd actually be paying less taxes under this than you would be under the previous framework, essentially, assuming you're following all the rules as you should be, right? You'd actually be paying less under this scenario.
Exactly, but only this is a good scenario for high net value investors. For the small investors, the new proposed regime is worse. And why is that? Because you don't have the exemption of 35,000 reais for small transactions.
Okay.
So you have this duality. Depending on how much you are like transacting, it would be good to do it in a local intermediary like a Brazilian VASP, or if you have a high net value, it would be cheaper to go for international, because you would not be able to use the exemption of 35,000 reais anyway. So it would be better to go overseas. So this is basically the main difference, But this bill of law it poses some concerns for the crypto economy in Brazil, and that is the reason why me and Eduardo, representing our law firm, and together with the Brazilian Association of Crypto Economy, we helped them to draft a technical note giving some considerations on our concerns, because the bill of law is saying that virtual assets are an example of a financial application, of a financial asset. But they are not detailing which kinds of virtual assets are going to be encompassed by this new regime. And why is that? If you take the other examples that they are given in this, that they are like described in the bill of law, they are more focusing on investment, on banking products, on like securities and things like that. But we know that some of the virtual assets in the market, some of the crypto assets, they are not financial assets. If you have, for example, a utility token to get access to a massage or some kind of goods and services, this is not a financial asset. You can have, for example, a flying ticket embedded on an NFT, and you cannot say that this is a financial asset. This is a financial application only because it was issued by a foreign airline company. So what concerns us is that they're not explaining what kind of virtual assets are going to be encompassed by that. And our federal law on crypto, the federal law 14478, it was very clever and did that. They say like secure tokens, they are with the Brazilian Security Exchange Commission. Payment and investment, etc., they are with the central bank. And they say that utility tokens, I'm just summarizing because they are not using this kind of technical words, but basically virtual assets that grant access to goods and services, they are not encompassed at all by the federal law 14478. So how can I say that on the bill of law 4173, utility tokens should be considered as a financial application, as a financial asset? It doesn't make sense, because they would encompass other assets and they will like make distortions to like the behavior of the taxpayer and the economy itself. So just another example, on the bill of law, you have a specific regime to update the cost basis of your asset, and you tax despite the existence of any kind of alienation, but you have the taxation under a minor tax rate. So some people are going to do that as a tax planning. But this specific new regime, they are saying you cannot do that for artistic works or gold. You cannot update the cost basis. So, okay, I would say, but for financial applications, they allow this. And they put the virtual assets as an example of financial applications, financial assets. So my question is, a token that represents gold would be allowed to be within this regime? Because from a formal perspective, because it is a token, because it is a virtual asset, would be considered a financial application. But its content is of a commodity. It's gold. And gold is not allowed to be in this regime.
So the physical gold would not be taxed, but the tokenized gold would be taxed, basically.
Yeah, so this mismatch is very, very bad for a situation. And they are not explained to us what is considered to be a foreign asset, because they are saying only financial applications located abroad. In the crypto realm, what is located abroad? Because we're talking about decentralized technologies. So would be the place of the issuing, the place of the intermediary? Because if it is the place of the issuer, we have a serious problem in Brazil, because more than 90% of our market is composed by foreign issued tokens. So if, like, from one day to another, we may fall into a scenario that all the Brazilian exchanges would be selling foreign financial applications. And I'm sure this is not the intention of the legislator. And this would like kill the market, because we would then be able to use the small value exemption. It would be more reasonable to have as a criteria for the localization the place of the intermediary, the place of the virtual asset service provider. This way we can like take all the issuing aside, you can take peer-to-peer aside, and this would be like for a fiction considered as located in Brazil. But the Bill of Law is not giving clarity regarding that. What they did was they are delegating competence and authority. They are saying on a paragraph number 3, saying, okay, we know that this is a very complex matter. So the Brazilian Federal Revenue will need to enact new regulations to say what would be the virtual assets encompassed by the new regime, what would be the virtual assets considered located abroad. At the end of the day, if you have the approval of this Bill of Law at the Senate, we will still don't know for sure what kinds of crypto and operations would be encompassed, because if things are approved the way they are now, we will need to wait for the regulations to be enacted by the Brazilian Federal Revenue.
So is it necessarily a bad thing that some of these more technical definitions and nuances and classifications of tokens and whatnot would be left delegated specifically to the Receita Federal instead of having Congress trying to pass a law that's, having these definitions codified in the law? Like, does it make more sense just for Congress to create kind of a broader umbrella and then or broader umbrella framework, and then just say, hey, okay, you guys, the technical people at the Receita Federal, you guys are the ones tasked with figuring out like the specifics of this? Is that, necessarily, is it maybe better in this framework, or it sounds like you're arguing that's worse, but like, we'd just love to have that discussion.
Perfect. So I would say around that, from a technical standpoint, it would be better, because it seems to me that the Brazilian Federal Revenue has it possesses more technical people that could draft very good regulation from under the law, right? However, there is, two things to take into consideration. When we have something in the law itself, codified in law, we would not be subject to, like, if someone who is in charge, the head of the topic, changes. If we have everything on regulations and this person is not so aligned with a crypto-friendly approach, it could by like from day night changing everything, a changing in the framework that could be like very important to our ecosystem. So codified in law, we would not have this problem, because in order to revoke a legislation, it is much more complex than revoke normative instruction, for example, or administrative ruling. So from a legal certain standpoint, I would say that being codified in law is better. However, the law is not fast enough to encompass new developments of the technology itself, And from that perspective, I would say that regulations are better because they're faster. If, for example, there are new types of token coming around, we are not, for example, rebase tokens. They're not so famous yet. And if this became like a phenomena on the next months or years, then we have, from the regulation perspective, is much faster to draft the regulations to encompass this new phenomena. So I would say from this standpoint, it's Sophia's choice. From a legal certain perspective, it would be better to have codified in law. For a perspective of like the regulation being up to date, being like encompassing new phenomena, etc., it would be better to give this authority 100% to the Brazilian Federal Revenue, because they have been doing a very good work so far. Actually, the normative instruction 1888 from the Federal Revenue, it's a benchmark. It's an international benchmark that has been used by the OECD, Organization for Economic Development, and also when they created CARF, which is Crypto Asset Reporting Framework, and also for the European Union when they create DAC8, which is also a reporting framework for crypto. So Brazilian Federal Revenue, I am totally comfortable to say that they have the knowledge and the technical perspective to have a very mature dialogue with the market, with ABCrypto, for example, the Brazilian Association of Crypto Economy, to draft regulations that would be a good fit to the market, you know. But besides that, and now I'm going more into a technical approach here, Brazil is a civil law country, which means that in order for something to be collectible in terms of taxation, we have to have that in law, stricto sensu, you know. So we have this provision on the federal constitution, Article 146, saying that complementary law should establish the minimum details of the fact that gives rise to taxation. And this minimal description of facts are the conduct that is going to be taxed, which is formed by a verb plus a noun, you know, like to get income, to deliver a service, you always have a verb plus a noun, you know, what is the fact that is going to be taxed. So this needs to be on the complementary law, which is now considered to be one of them, the national tax code, okay? But more than that, we need to have chronological and spatial rules disciplined in law. So the place where the fact is supposed to happen in order to be taxed needs to be written in law. So it's the legal certainty principle in Brazil for tax matters is very important. And when we go to the national tax code, the national tax code says that the law, again, needs to have the minimum discipline of this fact, the chronological when it happens and where it happens. Then you can delegate for regulations. But the regulation itself cannot create the conditions regarding the practice of the fact, where it happens, and when it's considered to be happen. So my concern is that even though the regulation is good, let's imagine the best case scenario. Best case scenario would be and we don't manage to have any kind of modifications on the bill of law. Okay, so let's assume the bill of law is going to be approved as it is today. And then the federal revenue will need to enact this regulation. I have no doubt that the regulations are going to be very equilibrated. You know, they are going to be like not focusing on tax collection, not focusing on protecting taxpayer. No, it's going to be neutral from technological standpoint because this is what they have been done so far. However, we cannot discard or disregard the possibility that some taxpayers decide to take this as a litigation cause to the Superior and Supreme Court and to say that, okay for the regulations to happen, but at least the minimum should be described in law. So we could have these taxpayers, and this would like cause a friction between taxpayers and tax authorities that I think it's unnecessary. So my point is, in order to prevent litigation, because I'm not against, or from a technical standpoint, from a researcher standpoint, impartial perspective, I'm not against the federal revenue having the discipline for that on regulations. No, I think they are going to do an amazing job, much more technical than what the Congress would be able to do, because crypto is one thing on several others on the Congress. So from technical standpoint, I have no doubts that this will be good. However, I want to prevent litigation. I want to prevent problems because in Brazil, we have a culture of litigation, which is very, very, very strong era. We are one of the most litigation countries in the world. We have one of the most expensive tax courts in the world. And I'm not criticizing the courts. No, it's because it's too many people demanding legal decisions. So we need to have judges, we need to have courts. And this is the problem, because it usually takes some years to get these matters solved. Just for you to have a glimpse of an idea, it took approximately 10 years to decide how software should be taxed in Brazil from an indirect consumption taxes perspective. So I want to prevent that from happening. I want to prevent that eventually any taxpayer says, okay, the regulations are good, but I don't want at all to be taxed. regarding these overseas operations on the new framework. So I'm going to sue the government and say that they have overexceeded their power because they are regulating something that has not the minimum descriptions in law, stricto sensu. So this is my concern.
Is
It's not
this
actually a better or worse approach. It's more trying to have a framework more connected to avoid further and future discussions.
so? It sounds like it's almost a twofold concern. The first being that the regulations are not necessarily set in stone, right? So if a new head of the agency were to come in, who's maybe has a different viewpoint on some things, they could obviously change some things around in a way that may or may not be positive. And then the second concern is really that some consumers could band together and they could start filing lawsuits against these regulations, saying that, hey, this isn't what the law was prescribing. And at the very least, you're just throwing a bunch of sand in the gears of the system, trying to slow things down.
Perfect.
And it'll take 10 years later, we'll have but it's like it's kind of like John Maynard Keynes, right? Where it's it's in the long run, we're all dead. So like it's like, hey, just file some lawsuits, throw some sand in the gears, and then maybe 10 years later we'll get a resolution, and we'll all be dead by then anyway. So who cares, right? So it almost feels similar, or this dilemma you're describing feels similar to the asset segregation dilemma that the central bank has been facing, where they've come out like, hey, we're very pro asset segregation, we really want to do this. And they came out kind of guns blazing, earlier in the year, saying we're going to do this. And then now they've kind of walked back some of the language. They're like, we want this, but we don't think we can do it just by enacting regulation because we're probably going to get sued. And we're going to end up in that same type of situation we just described. So now they've been going back to the Congress, pushing for legislation. I mean, is this a fair comparison? Is this kind of the same dynamic here?
It is indeed, Aaron. It's a fair comparison, and I think they are right to try to, for example, regarding this regulation, to do that in law. More or less, it's a similar approach. It would be better if you have in this bill of law very minor changes. For example, it is considered to be encompassed in the law only virtual assets that are comparable to financial instruments. This would solve the description of the facts, which is the material perspective of the text. Then the chronological perspective. They could state that, for example, the taxation is going to occur until the end of the next month. Okay. And the third aspect, which is more related to the geographic location, they could say that what matters to consider a crypto of a foreign geolocalization, a foreign origin, they could say that is the place where the intermediary is located. With these three minor clarifications, I think the authority would be legally delegated to the Brazilian Federal Revenue in order to detail that.
Got it. And then I wanted to ask just one sort of, or probably a couple more wrap-up questions here, but I wanted to ask sort of a reframing question, and which is really, and you've kind of explained some of this already, so I apologize if it's a bit redundant, but I just kind of want to like reframe and repackage. But basically, like, how is this, going back to like how this affects the your average Brazilian crypto user or trader, perhaps somebody who's not like a whale, sitting on thousands of Bitcoins or whatever. And the reason I'm asking this is because my Instagram feed has just been like lit up with crypto influencers, talking about, oh my gosh, there's this new 15% taxation rule, and and people freaking out about it, and like, granted, like they're doing the same thing I'm doing and creating content and trying to get people to watch it, whatever. So more power to them. But it sounds like from what you're saying, you've been describing here, that the situation's a lot more nuanced than just like, oh no, the Congress is trying to tax you 15% of your crypto. It sounds like there's a lot more nuance here. So would love for you to kind of maybe like just reframe, repackage, like what's the impact that this is going to have on just kind of your average, maybe like small retail, large retail user, should this all be enacted as it stands today?
Perfect. First of all, Aaron, I would say that I share more or less what you just described. So there's no need to be so chaotic about it. I think the news that I have been seeing and reading, they are not technically accurate. They are describing something worse than what is going to be enacted, and more than that, they are never telling the end user that now. Let's imagine that this bill of law is not approved. If it is not approved, foreign crypto assets that have been acquired from foreign sources, they are taxed in Brazil because you are a Brazilian resident. So this is what concerns me. Why are people so euphoric about that and say, "Oh my God, our cryptos that are in foreign exchange, they are going to be taxed"? No, they are already taxed. If you're not taxing it, you're doing it wrong, because we have a worldwide income system, and this is not Daniel telling, because usually people, some users and some crypto lovers, they get mad at me because they say I am against the ethos of crypto, but no, I'm just describing how things work. The same way a dev would describe how Ethereum work, I'm saying how things work on the tax law, and the tax law now already taxed crypto located in foreign sources. So nothing has changed. From a status quo perspective, we still keep being a worldwide income taxing country. So what is going to change if this is enacted now? Let's first deal with the real scenario, which is the bill of law probably is going to be approved the way it is. So if the bill of law is approved the way it is, what we have is that a comparison, an example in the form of an example, saying that crypto, but they are not using the word crypto, and this was a formal approach that we took as the Brazilian Association of Crypto Economy to substitute, to exchange the word crypto asset, which was on the original text, for the expression virtual asset. And why we did that? Because there is no definition of crypto asset in any law. So how we would have a bill of law talking about taxing offshore or foreign crypto assets using the word crypto assets if we have no definition of crypto assets? So it doesn't make sense. What is the definition that we have? The definition that we have is virtual asset. So this was a first topic that no one is talking about, and we managed to explain that to the Congress. The OAB, which is also the organization of representing the lawyers, and the Association of Brazilian Crypto Economy, they said the same thing. They said we need to have a standardization regarding the terminology. First things first. So they substituted crypto assets by virtual assets. Great achievement. And if this is approved as it is now, what is going to happen is the following. Instead of having, as we have today, progressive tax rates going from 15 to 22.5%, we are going to have a fixed rate of 15%. So it seems to me that making your transactions using foreign intermediaries, it would be tax efficient from a nominal tax rate perspective. And this is very important, a nominal tax rate perspective. And why is that? Because I'm telling you that in the ordinary system, in the ordinary framework that we have today, we have progressive rates according to the basis of the values that are going to be negotiated. And these values are quite big, going in case of millions and millions of reais. But in the new rule, we have a fixed rate regardless of the amounts transacted. So this is the first thing that would change. The second thing that is going to be a controversy, the exemption that we have now for small transaction value, which has a trigger of a ceiling of 35,000 reais. So if the total of your transactions in a month does not supersede that, then your transactions are exempt. There's no detailing on the bill of law regarding how this exemption would be applicable to the new framework. My guess is that it's not going to be applicable because there is a paragraph saying that all the other cases, I'm just summarizing here, all the other cases in which the new framework of this bill of law is not going to be applicable, you go to the ordinary framework from the federal law number 8981, and then this is the reason why I believe that the federal revenue would say the small value exemption is going to be applicable only for the domestic market. But this is also debatable, So probably this is one thing that is going to happen. Who operates by foreign exchanges is going to tax 15%, regardless the amount involved. they have, I think, a zero tax rate only for values transacted upon 6,000 reais. Over that you have 15%. So this is a very serious difference between the two frameworks. But the third point that I will say, and this is like very important, because what the chaotic people are saying is that, oh my God, if this is approved in the Senate, then we have this new framework. Calm down. And why is that? Because if they approve like that, we have this provision saying the federal revenue needs to enact regulations saying which kind of virtual assets are going to be encompassed by the new framework, and when or how we are going to qualify something as a foreign location. While we don't have that, the law itself does not grant the power to tax these operations in the new framework. Because either you have everything in the law, as we tried to do it, everything in the law, and then once the law is enacted, the new regime is going to, like, we need to respect some national rights of the taxpayers, which is that we have a period of time that needs to be respected before collecting the new taxes. So what we call anteriority, it's connected to legal certainty. So they only can ask the collection of these new taxes if, imagine, it's approved this year, only in next year, and they also need to respect a 90-day period of, like, grace, I would say so, in order to start collecting. So we would need to wait the next year, and then from the date of the approval this year, 90 days also as a plus. So it's not from day to night. This is the first thing. But considering that they did not insert in the bill of law the minimum requirements for the tax collection, we need to wait the regulations for the federal revenue. So we only need to really say, okay, now things have changed once we have the bill of law approved. And if the text is the one that we know so far, delegating authority for the federal revenue, we will also need to wait for the enactment of the regulations by the federal for the tax authorities in Brazil. Before that, nothing changes for the end user.
Got it. So what you're saying is kind of what we were talking about earlier. The larger traders are who would use, like, the offshore exchanges, basically hit it. Who would they would probably blow over that 35,000 real threshold
Exemption.
anyways. Exemption. They would blow over that exemption, or they would be trading much larger than that exemption. So, like, they would benefit basically based on just being able to just at that lower tax rate than they would otherwise being taxed at the 22.5 rate. But your smaller retail traders who might be using these exchanges, who would otherwise trigger that or they would otherwise not trigger the exemption, they would be under the 35,000. They would end up being taxed on that income where previously they would not be taxed on those capital gains, I should say, not income. And then, but I know what you're saying is, so would the Receita Federal, the tax authority, have the ability to create an exempt, like just reuse that same exemption or create a new exemption, or is that something that would have to be codified in the law itself? If they want to take, hey, we're going to take this 35,000 real exemption and we're going to repurpose it in this new scenario, is that something they can do, or is that something that they need the legislative approval for?
By the literal description of the law, any kind of exemption needs to be enacted by law. So the National Tax Code tells us that. However, they could try to build an interpretation on the current rule, saying that they are just applying the current rule, But in my opinion, it's too soon to understand how they are going to navigate this framework, because we would need to understand what they are going to consider as a virtual asset encompassed by the new framework, and what they are going to consider as a foreign origin virtual asset.
Yeah, the foreign origin virtual asset piece. I was going to dig into this a bit earlier as well, but I mean, this seems very problematic, just in the sense that that's basically, I mean, what's the origin of Bitcoin? Like, where did Bitcoin originate?
Yeah.
Like where is it? Where did? Yeah. Okay, you can argue maybe Ethereum. Okay, maybe it's Zug, because that's where Ethereum Foundation was based, and they were the ones that at least emitted the original token and the ICO. But with Bitcoin, like where's the, it's like asking like, well, who's the creator of Bitcoin? Like, I want to talk to the CEO of Bitcoin. I want to know where Bitcoin was created, like what country, so I can tax it properly. It's like, well, it doesn't
I
exist,
think
right?
it's a huge challenge, Aaron, because at the end of the day, imagine like AXS, from Max Infinity, there is Skymaves Labs. We could say, for instance, that because Skymaves is a foreign software house, gaming house company, this would be considered as a virtual asset with foreign origin because the issuance occurred abroad. But as I said, it seems to me that this criteria is not very good because, uh, you know, this way, basically all the cryptos being sold in the Brazilian market, they are foreign financial assets, they're foreign financial applications. This doesn't make sense. And also we have the problem that you just mentioned about Bitcoin, because we have pre-minted platforms, pre-minted protocols that you can find an issuer. But you also have a self-generation protocol like Bitcoin. Usually proof of work does not work with pre-minted systems or pre-minted tokens. So how they are going to do that? It seems to me that this criteria of the source of the issuance is not a very efficient criteria. It would be much better to have an abstraction regarding the place of the issuing, and use instead the place where the intermediary is located. So this way, I think, for example, you have a foreign exchange negotiating Bitcoin. In this case, it's a Bitcoin considered from a foreign origin. You're buying Bitcoin on a local exchange. Okay, this is a domestic Bitcoin. It seems to me that this nexus is much more efficient than the place of where is located the issuer. Otherwise, we would just ruin the crypto economy with this kind of rules.
Yeah, absolutely. Well, great. Well, running out of time here, but really appreciate you coming on the show to help explain some of this stuff. It's very, very nuanced, very technical, but also very important. And you articulate it very well, especially in a different language. So congratulations, and thank you for helping me to understand and all of us better understand this. And any final thoughts from your end, or anything else you'd want to add? And then also, how can folks get in touch with you if they want to connect?
Great. First of all, I would like to thank you, Aaron. I think we have been discussing the day in which we would have this talk, and it was an amazing experience. Thank you a lot for the invitation, and I would like to congratulate you to have this, to being sensible towards technical aspects. Thank you so much also for the positive feedback. I always try my best to be a non-legal speaker. I need to talk about legal stuff, but I try to do it in a very natural language, because this affects all of us. It should not be a technical discussion because it affects all the people. So I'm truly honored to be here. And if anyone wants to reach out, I have my Instagram with my brother, which is Os Irmãos Paiva, Paiva Brothers. I have my LinkedIn. I'm very active in LinkedIn too. Actually, me and Aaron, we will start talking on LinkedIn, which is my full name, Daniel de Paiva Gomes. And anyone who needs to reach out from a more deeper and technical analysis, I would be glad to help. This website of my law firm, which is vdvadv.com.br. You can find my email there, and it will be a pleasure to get in touch. I would like just to give a final piece of advice, because usually we start trading, we start buying and selling, and we leave for later to plan our financial lives. Don't do that. I'm not saying that people need to have a very expensive advice, but they with anything that we have discussed here, they can do by themselves. They don't need to expend money, spend money doing some legal research, etc. I would advise them to go into Google and type Brazilian Federal Revenue Q&A, which would be in Portuguese, Guia de Perguntas e Respostas da Receita Federal. There, you just make a search on the document, you type crypto, and then you would see how the tax authorities are understanding this economy. It's very important for people to have the origin of their wealth, because at the end of the day, I want everyone in the crypto economy to be rich. but they need to have the origin for this wealth, you know. So my final piece of advice would be like, once you start doing it with more volume and you have more money and you start to get profit, start to look for the compliance too, because at the end of the day, it's much more expensive to pay higher taxes and penalties because you were not compliant than doing that at first instance. So this is my final piece of advice, and I thank you again so much for the honorable invitation.
Yeah, amazing, amazing. Yeah, that's I felt like you were speaking to me directly there. I will say, it's like sometimes it's like the advice you don't want to hear is the stuff you got to listen to the most. You know? So, but anyway, but appreciate you on the show and sharing your knowledge here, and very impressive just the work you've done and how much you've invested into understanding this all, and really appreciate just everything you've brought into this particular episode. So, thanks so much, Daniel, and thanks everyone for listening, and we will see you next time.